technicalities. It's sort of this, and therefore it's a low-income project, but it's not that. Can you give a sense of what's the gist of this article and why does it restrict such a project as RAT?
I can't help but first say, if anybody's trying to trip someone up on a technicality, it would be them saying that we're untimely and we can never have our claim heard because we went to federal court and they told us that we couldn't go there, and then when we went to state court, now they're saying we can't go here. But I appreciate your point, and the reason it's far more than the mere technicality, and I admit to being a little too steeped in the Constitutional Convention of 1938, but if you read all of those documents, the reason the Constitution provides the state with the power to provide this kind of money to address a very serious problem, particularly the slums at that time, the old law tenements, was specifically to provide low-income housing. And so it's not a mere technicality, it's a very serious, important, substantive requirement that when our public money is being used and we're condemning private property and we're giving it to another private person for their benefit, that when all of those things line up, that money should be used to provide low-income housing and not luxury condominiums.
And then there was something about the gift clause as well.
That's even
played into this.
Yes, more complicated. But in 1938, when Article 18 was passed, part of the reason it was passed was because there's another provision in the Constitution, the gift clause, that prohibits, quite appropriately, we would all agree with this, the state from just giving money to private people because they feel like. The legislature can't just allocate $100 million to Matt Brinckerhoff, however much I would love them to do that, because the gift clause says, no, you can't do that. And what they were concerned about was if they wanted to give money to a private developer to create low-income housing, would that violate the gift clause? And so they expressly said, if you're doing that, if you're clearing slums and you're providing low-income housing, we don't have a gift clause problem. It's not like just giving money to Matt Brinckerhoff. You're doing something that's very beneficial to the public, and that you can do. And that's why the gift clause ended up being a part of that analysis back at that time. It still exists.
So there seemed to be a problem in your brief about the fact that there was just an arena project and they could use this money to clear slums and subsidize it. But because there was a little bit of housing or some housing and the arena, that couldn't be done. That's what I'm talking about in terms of the technicality.
No, that's
What's
right.
The big picture? Why can't somebody do that?
Well, I mean, it's not unheard of. They were trying to balance a lot of different interests when they drafted this article and when it was voted on by the people. And they were trying to recognize that you can have a circumstance where you're just clearing a slum, which is a good thing to do, and you can have a circumstance where you're just creating low-income housing, which is a good thing to do. But what they said in Section 6, which was a late amendment, very clearly, was when you combine the two, and you provide state subsidies, there has to be a restriction placed on that. It couldn't be more clear. The last sentence says very clearly that occupancy will be restricted to persons of low income. And you're right, it only applies in a very narrow set of circumstances. It happens to apply here. And its purpose was exactly for this kind of situation. Because you basically have a developer that's profiting enormously off of this, and they're not limiting the housing to persons with low income, and that's what Article 18, Section 6 requires.
The problem is the market rate housing part of it. The problem is not the arena plus low income. What if it was arena and just low income?
If it were arena and just low income, it would be fine. It would be absolutely fine, because the restriction just says if there's occupancy, which means there has to be housing, it's restricted to people with low income.
There was a question about when Blight was announced. I think Mr. Carmel said something about an MOU, which was early 2005. Obviously, the project was announced in 2003. Is there anything in the record about when this sequence sort of happened?
It's certainly in our petition, we made it very clear that when the project was announced in December of 2003, there was no mention of blight. I think some of us here remember it really well. It was, hoops, housing, and jobs, or something like that. It was always about economic development. And we always also said that the record was clear, because if you look at the MOUs, they don't say anything about economic development.
Talk about it, sure.
That it first came up when they hired the AKRF in late 2005. And what he said there was the first time I'd heard it certainly wasn't in the brief, was he basically was intimating that because there's a reference to a Torah, that's the indication that this was always about blight, which I think is a very sort of thin reed to hang that on. But be that as it's may, that's what he said. I assume it's in there. I don't remember. You might for the MOU.
The judges seem to be sort of skeptical of the idea that Blight had been mentioned, and sort of openly question whether it was just convenience.
I mean, there's no doubt one of the things that I wanted to talk about and didn't when I was first arguing was the issue of pretext, and certainly the judges brought it up. I think they understood the timeline. That much seemed pretty clear to me. And so that combined with their understanding of the difference between the blocks south of the Torah and the blocks north are both, signs that make me feel cautiously optimistic.
They also seem to be saying that isn't this the job for the legislature? If they haven't reformed eminent domain law in New York as opposed to other places, isn't that the job for the legislature? Aren't you sort of asking them to say you should reform eminent domain law in a way that hasn't been done?
Well, I mean, there's obviously a problem in New York at all times in relying on the legislature, but that I think has been borne out particularly in recent months. But yes, the legislature could do something. The legislature could protect individual rights more than our Constitution does, at least in theory, certainly could. And it's definitely happened in some other states. The reality is that unlike in some of the other states, we have this rich historic tradition of being very protective of individual property rights in this context. And I think it's really set out very clearly in the briefs. It didn't get a lot of attention because there's so many issues that the court is trying to deal with. But this is a matter of state constitutional interpretation, which isn't for the legislature. It's obviously not their job to decide whether or not the Constitution has restrictions. Certainly, if the court is inclined, which I think it shouldn't be, but if it were inclined to just say, we agree with Kelo, we think all bets are off, we think the government can do anything it wants to do constitutionally, then the only place that we're going to get any relief is the legislature. That's clear.
They seem kind of right at the outset, correct me if you disagree, but a little skeptical of that general argument that there should be a narrow definition of public use. Are you kind of pinning your hopes more on this point on the pretext thing, with the argument with the blight as well as the low-income housing restriction, or do you still think there's a chance I mean, I know you can't predict. But
well, no, and not only can I not predict, but I mean, I have been doing this long enough to know how much sort of folly is inherent in that. In this kind of a court in particular. I mean, you have to recognize the judges came into the argument today without, in all likelihood, having spoken or reached any kind of a consensus about how to handle this case. And they're just sort of starting to grapple with these issues orally for the first time. They'll probably meet tomorrow morning and start to discuss it seriously in detail. And anything can happen during that process. And not just during that part of the process, but during the writing. Because whatever seems like a good idea in theory when you're talking about it, when you try to write it and justify it and make sure it makes sense and start thinking really deeply about the ramifications, things change. And so for all those reasons, it's always, a very, very dicey business to be predicting a result based on an argument. I understand your point. They certainly had some skepticism. It's their job to, and they had skepticism of the other side's arguments too. I mean, that's one way in probing and bringing out those kinds of questions that you can help focus your mind on what the right answer might be. It's part of the process. I wouldn't read too much into it.
Isn't it a little risky? You've thrown out blight. You've thrown out blight for them to rule on, whether or not this was a precept or pretext, excuse me, or not. Whether New York State is more restrictive than Kelo. Whether Article 18 applies. Isn't that a little risky to throw out so many different? Why are you pursuing so many different lines for them to? In fact, one judge asked, what do you want us to rule on? And it seemed like it wasn't really clear.
Well, I'm sorry. I'm not happy to hear. What we want them to rule is that they're rejecting these determination findings. It's the only relief that they can provide us. There are 3 different ways, at least, probably 4, that they can do that. The reason we're offering them all is because they're all substantive, legitimate bases on which to rule, and any one of them, we think that we're right in our analysis, and so we have to. I mean, it would be foolish to just pick one when we have 4. I've certainly been in a situation where I only have one, but here we have 4, and they're all independently very viable and powerful. So that's why we're offering them all 4. They can pick whichever one they want, and they probably won't pick more than one. It's not the nature of a court to do that.
Thank you.